And please, would you please stand for the invocation delivered by Gillespie County resident Susan King and remain standing for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Be seated. Ceremonial matters, proclamations, and employee recognitions. Bailey.
Okay, Mayor, Council, members of the public, I have 3 employee recognitions this morning. One from the Water Department, one from the Police Department, and one from our City Attorney Department. That kind of narrows it down a little bit.
Small department.
Yeah, that's a small department. So I will start with the Police Department. Dennis Dicker. Dennis with us? I'm sorry, not Dennis Dicker. Officer Martinez. Dennis Dicker made the phone call. Officer Martinez, come on up, please. So as he's coming up, Dennis Dicker left a voicemail a couple of weeks ago stating that he had accidentally set off his burglar alarm. We responded to those things pretty quickly. Pretty embarrassing in this particular situation because it went off by accident. It was actually the homeowner's issue. But he wanted to commend Officer Martinez on his professionalism. Wanted to say thank you very much for his prompt attention to this stupid act and appreciated it very much. In fact, he gave him a gold star. Do you have the gold star with you today? All right. So he gave him a gold star. So congratulations, Officer Martinez. Try to get this right this time. Quentin Mellering, Water Department. We talk about the small things all the time. It's not the replacing a water line or operating a piece of equipment or getting a certification. It's the small things that really separate people that just do their job from everybody else. And that's something that we've always talked a lot about in public works. look for those small things. In this particular case, I'm not sure how Mr. Mellering saw this, but on a Sunday, November 27th, there was an Amanda Williams traveling on Highway 290 when someone in the water department flagged her down. When she pulled over, Quentin indicated to her that she had a bubble on her tire. I'm not sure how you saw that.
Well, she was driving down 290 and
So again, real easy just to say, good luck with that. But he took the time to flag her down, pull her over, and help her change the tire. So these are the things we're talking about, and I think that is the spirit of this organization is helping out, not only across department lines, but helping our residents and our visitors. So that's really what it's all about. Thank you, Quentin, for a job well done. Keep up the good work. Mr. Jones, could I have you come up here, please?
the whole department.
Yeah, bring your whole department up here, Dan. I'm really not sure what to say in this particular case. Daniel came on board years ago, and he was automatically a wonderful fit for the organization. And having worked with a number of city attorneys throughout my almost 30-year career, I can say that he's definitely at the top of the list. Wonderful individual. He's done wonderful work for the city. A wonderful friend, colleague. We know that relationship is going to continue when he's across the street. Looking forward to a wonderful relationship with the county, looking for opportunities right now, even before he takes that office. So I could go on and on about the job you've done, give several examples. I can talk about a lot of the impacts that you've had on the organization, professionally and personally. I'm sure everybody has very similar stories, Daniel. We're going to miss you. I know you're excited about the opportunity, and we'll do a wonderful job over there. So congratulations to you, and thank you very much.
Clinton forgot to mention the wardrobe issue we constantly have. I don't know if you noticed today, but we always very frequently show up in the same outfit. So happened again today. Thank you.
You know we're in the Christmas spirit when we give a standing ovation to an attorney. Well deserved, Daniel, and you will be missed in this role, and we look forward to interaction in your next one. Council comments? Ms. Joseph, you have none?
I'd just like to say Merry Christmas to everyone and hope you have a safe holiday and look forward to next year.
Same thing. Happy holidays, Merry Christmas, Happy New Year. Looking forward to great things in 2023. Hope everyone can stay healthy.
All right. We'll move to the consent agenda. Consider approval of City Council member minutes for the December 6th meeting. Any comments or accretions or revisions or whatever, Council?
I move we approve the consent agenda.
Second.
All right. Motion to approve the consent agenda. All in favor say aye.
Aye.
Thank you. Motion carries. Item number 7A. Anna, would you make a comment about how we're going to handle this today, please?
So we will have a public hearing and a presentation, and you will consider the ordinance for the text amendment for the short-term rental two definitions.
Okay. I'd like to make a comment before we go into public hearing. The task force is in operation, and we've had 4 meetings, and I personally can't say enough good about the participants and the way that they are handling the issues and the progress that we're making. The discussions have been so far mostly about the enforcement issues on what we would, I guess, generally call the nuisance issues that are disrupting neighborhoods with too many people being outside after hours and that sort of thing. Trash, water, noise, lights, and so forth. We do have the new administrative hearing process in play, and that's working. It seems to be working well so far. It's only been a few weeks. We will continue through January. Now, there was some information that went out about what we're going to do on this item, that why aren't we waiting until the task force makes its recommendations? And also some concern about why are we doing this right before Christmas when we're trying to sneak something in when people can't appear and so forth. It's my hope that as we continue along that this council continues to prove to you its integrity, that we are not people who will say one thing and do another. I know that's proofs in the pudding, but that's who we are. We don't make commitments. I can speak for myself for sure. Make a commitment and then renege on it and hope you don't notice. That's not the way we operate. But I understand that it's sort of the signs of the times that people don't trust government and they think they're always on the make or doing something nefarious and so forth. So this is my testimony that we do not do that. So we're on this item today because I considered it to be urgent with regard to a recent court ruling. And it's tidying up some language in our ordinance that requires tidying up because it is exactly language that was ruled unconstitutional by 5th District Court, New Orleans, which we are in their jurisdiction. We could have waited another couple of months, yes, or until the task force is over, but the task force is not actually dealing with this particular issue. And I did inform the task force before we dealt with this and before I put it on the agenda, so they're fully aware of what the issue was and we're not pulling the rug out from under their task. The Fifth Circuit Court of Appeals ruled that a New Orleans ordinance that required in STR, in our case, facilities and B&Bs, that the owner be in residence and that it be proven by a homestead exemption. And the court said that we know what you're trying to accomplish. We know that you're trying to accomplish having a resident owner who can control the behavior of their guests. See, there's a B&B, which we don't have many anymore, right? Where you own a property and you rent out the rooms in your house. The kinds of things that really identified Fredericksburg in the day. And then the STR facility where you have a main house and then you have another property on another structure on your property that you rent out as an STR. Those two particular cases in our ordinance from the previous city council required homestead exemption for those owners. That's exactly what the court ruled was not okay. And well, actually unconstitutional. I guess that's the way to put it. In the court briefing, the judge wrote that we know what you're trying to accomplish, that you're wanting to have somebody on site who controls the behavior of the guests and doesn't disrupt the neighborhoods and so forth. But you picked the one way that's unconstitutional to do that. And also in the brief or in the report, what do you call it, Daniel? What's the post-trial document called? I want to get it right.
The order or the judgment?
No, when they explain why they decided what they did. Is it a brief?
Oh, the court's opinion.
Court's opinion. Right. That's a very tough term for me. Thank you. The court's opinion. It was listed several other remedies that could accomplish some of the same things, but not the one that the New Orleans City Council chose. So I felt that it was urgent that we get into compliance since the decision had been made. So that's the reason we're doing it on December 20th. We found out about this a few weeks ago and recognized that in our ordinance that was the case. I do want to state, and The previous council dealt with this, as you know, many of you were here during that debate for a year and a half or whatever it was about the STR ordinance that became effective April 1st. That I checked on the activity for, which is pertinent to our discussion. I checked on the activity for STRs in R1 since the ordinance went into effect April 1st. And as of yesterday, what I received was, and I don't have, let me see if I get it up here. I want to make sure that I don't say anything that is incorrect. How many STR CUP applications you know in the ordinance that went in April 1st? R1 was prohibited for new STRs except for through the conditional use permit under certain conditions that they had to apply and comply. How many STR CUP applications for R1 properties have been submitted after April the 1st? And the answer is none. No R1 properties have submitted since April 1st. How many R2 properties have made applications under a CUP since April 1st, 2022? And the answer is 6. And all but one is in the historic district, R2. How many STR applications for R1 properties are in the pending category since or prior to April 1st? Because there was quite a lot of activity prior to April 1st, people wanting to get in under the application of the new ordinance. 32 applications are pending in R1 for a new permit as they were submitted prior to April 1st, 2022. And the same question for R2, how many STR applications for R2 properties are in the pending category? 28 applications are pending in R2 for a new permit, and 12 are pending under the 2018 STR ordinance, and 16 are pending under the 22 STR ordinance. So I wanted to get those facts out, Council, with regard to what is going on today with regarding STRs. All right. I'll take a motion to go into public hearing.
So moved.
Second.
Motion second to go out of regular session into public hearing. All in favor say aye.
Aye.
All right. Shall we go right ahead to the comments? I just have them in the order it handed to me. Jason Lutz.
Jason Lutz, 305 East Burbank. Wanted to come today and just let you know that I don't have any issues with the definitions, the amendments themselves. My concern is more with the kind of unintended consequences that come with making a change to a definition like that without doing some other changes to the code. So my house, 305 East Burbank, I have 4 adjacent property lines that are short-term rentals just immediately. Works out to about 1,976 neighbors a year on paper at a minimum. I know that is quite more than that. I would say that if the next step needs to probably look at prohibiting the STR accessory unit in the R1, or make modifications to the language in the accessory structure section, because the way it's currently written, if you pass this ordinance today, tomorrow night, I can have 4 new structures in my backyard. They can be 1 square foot smaller than the existing house. They can sleep the same amount of people, moving them closer to my family's bedrooms. And then they can still add the homeowner in the front that lives there. So I feel like almost 2,000 neighbors a year is enough. But if you make this ordinance change without making any other changes, then it's going to push that over 2,000. And that's just something that's, I don't think for R1 is intended for the use. Secondly, I would look at changing not only the definition or size of the accessory structures, I would look at the occupancy. Instead of going 2 per bedroom, which the last council went with, I would stick with the building or property maintenance code, which does a square footage, so that there's a life safety issue involved, and not just an arbitrary number per person. Other than that, again, the only other concern I have is on the effect on the intent of the ordinance. Obviously, housing is key for this city. We've talked about it for several years. What the last ordinance did, it allowed people to try and buy houses again. without competing with investors. By allowing renter up in front and STR in the back, you're re-incentivizing those investment properties, making it more difficult for citizens again to try and own property here. And then I think lastly, that the big concern out of that is just it pushes code enforcement issues further into the backyard. Code enforcement is not a silver bullet for STR issues. It is a tool for voluntary compliance. That's why most cities change their cities to code compliance officers. So to think that we can code enforce our way out of this is just not going to work. So those are some of the issues I have with the ordinance. Again, I have no problems with the definition changes. I just think that we need to take a more holistic approach and make sure that we're covering all the bases and not triggering a bunch of unintended consequences. Thank you.
Thank you. Mr. Musselman.
Good morning, Council. I'm Tom Musselman. I'm a member of the city's Planning and Zoning Commission, and I have a question that I think needs a clarification that needs to be made, at least for the Planning and Zoning Committee. The question that has been on my mind revolves around the STR accessory building. I know that the code says that if you have a lot that's 10,000 square feet, you can put an accessory building on it. So the question I have is, this ordinance says that to put an accessory, you must have someone, either the owner or an owner representative, living in the first structure on the property. Does this apply solely to R2 in the historic district and R1? Or does it apply to all R2 properties? Because my understanding, and this is where I would like the development department to give some clarification to planning and zoning. Aren't STRs by right in R2 that is not in the historic district? So I own property on Friendship Lane. I've got a little over an acre. And according to my understanding of R2 right now, if I wanted to put STRs or B&Bs on my property, I could put a certain number, I think 5 or something, on my 1 acre. So the question is, would I have to have in R2 somebody living on the property full time as the gatekeeper? And I think this is the information that planning and zoning needs to have moving forward. Okay, so thank you very much.
Thank you, Tom. Lauren Smith.
Hi, my name's Lauren Smith. I'm 24 years old, and I moved to Fredericksburg about a couple years ago. Back to Fredericksburg. I was born here. As you already know, it is challenging to find affordable housing, affordable renter, even a renter at all, at any price for someone like me who's just starting out but wants to build a life here in Fredericksburg. I'm asking you to consider changing the wording of the text of the current ordinance to allow the larger of the 2 homes to be an STR and leaving the ADU for a long-term renter. The wording that you have in front of you today won't really change things for young people like me who need small, affordable renters. It won't really change much anything at all. Unfortunately, leaving so many ADUs that are currently still sitting empty because only one of the 2 structures can be rented. These ADUs could be used as affordable long-term rentals for single people like me or even for a young couple. Even the apartments are not really an affordable option for me and so many of my friends. By allowing the ADUs to be used as long-term rentals, it opens up many options for me. While the way it is worded in front of you, I would have to rent the larger house on the property, which would be completely out of my price range. I also would be happy to be the contact person for the guests if there were ever a problem in the main house. So I see it as a win-win. I get a place to live, and the neighbors have someone actually living on site with an incentive to keep the noise down. I just wanted to bring to your attention that one small change to these definitions could easily provide 2 things. Many more long-term renters for local Fredericksburg residents living in town and someone on site keeping an eye on things. So I respectfully ask you to consider this change. Thank you.
Thank you. Mike Mahoney?
I'm Mike Mahoney. I'm a resident of Fredericksburg. Uh, First of all, I would like to take the opportunity to say that this doesn't change anything in R2. If you look at the ordinance, R2 allows all of the STRs in R2. So changing something related only to accessory structures in B&Bs does not affect R2. R2 is still what it has always been. Whether that's a wise decision or not is another question for later. The comment about having the larger unit used as an STR and the smaller unit used as the residence house distorts the very intent of this provision. The intent was that in R1 we were going to continue to allow limited, very limited STRs in that section. They were to be incidental to the residence use. You could use the casita. It couldn't be bigger than the main house, but the goal was that it would still be a residential neighborhood and not a predominantly STR function. So to flip it the other way around would change that. And I think that the council and P&Z has done a good job here with this language to minimize the impact. We're getting around this unconstitutional requirement that the court put on us that says it's violates the Constitution to require a homeowner exemption there. I think we're doing it in the most limited way we can, and I strongly support it. Thank you.
Thank you, Mike. Is there anyone else that wants to speak to this? All right. Oh, Brady, did you want to speak to it? Or are you just standing? Oh, you're good. Okay.
I move we go out of public session into regular session.
Motion to go out of public hearing in a regular session. All in favor, say aye.
Aye.
All right. Presentation, Ms. Hudson.
Thank you, Mayor and Council. Mayor, I think you did a good job explaining why we're here. And then if we look at the actual language that we're proposing, it is pretty minimal. It's pretty to the point, essentially striking the requirement for property owner as a principal resident, giving in or the local contact person as evidenced by a sworn affidavit, principal residency. And then remaining the guest house shall not exceed the size of the primary structure. And that's for both STR accessory and STR B&B. Those are the only two definitions we are proposing to change. If you want me to address some of the comments that were made, or
However you'd like to,
okay.
you got to pursue that.
I think there's always a chance for unintended consequences. That's definitely a possibility. Trying to project how people will use these changes to their benefit. Obviously, the intent is to put us back into compliance with the Constitution, to not be unconstitutional. But that's not to say that there couldn't be unintended consequences with how prospective buyers use an R1 property now that would be able to use a long-term and short-term rental. Let's see, Mr. Musselman's about R2. I think he's talking about this, the way it's written, we're just changing the definition. So wherever STR accessory or ADU is allowed, that definition would apply across the board to all zones. Right now, an R2 unoccupied is allowed by right, so not requiring anyone to be there. And then if someone were to apply for an accessory or a B&B, that definition would remain intact as far as requiring someone to live there. And R2, if you to have more than one, that would be a facility, and facilities are only allowed in certain areas in R2. And then the others about the switching the side, which structure is rented out. I would agree with Mr. Mahoney. That's how I recall the intent of R1 was to keep it the residential and long-term rental as an ancillary use, or STR as an ancillary use.
Just a note, if you downloaded the packet on page 16, where this, the first memo is on this issue is described and under staff recommendation. Am I correct, Anna? Planning and zoning met on December 7th and recommended approval
Approval.
unanimously.
Yes, sir.
There were many comments submitted from the public about this, both STR owners and interested parties, and not STR owners, but still interested parties. And there was some confusion about whether it was an approval or denial, because some would circle denial or protest, whatever the language is on the sheet, and then their comment would be in approval. So this is my encouragement. We've discussed this in-house, but I just want to say publicly, this is my encouragement for us to take a look at those things that we send out to the public, and to work harder to be clearer, so that people feel like they're getting the full story, even if it's one or two sentences that explain it in non-city ease, if that's possible. I don't know what the legalities are, y'all do, but I know I've received these, not about this issue, but others before, and what is this about? And I know it's about 200 feet, et cetera. But I would like to encourage us to take a look at, I'd like to encourage staff to take a look at those notices, to have even an addition to it that has a deeper annotation. My opinion is that when there is broad misunderstanding between what the city is saying and the public understanding, that it behooves the city to take the lead in correcting it. And I know you all work very hard at it, and I appreciate it. Just a nudge. All right, council, what's your discussion on this?
I have some questions, Gerald, about your some of the figures with respect to R1 application since April 1st. Was that for only cups? And were there any of those that were R1 accessory dwellings or B&Bs?
My question was specific, so she answered it into my specific, Emily. So that's the only way I know how to answer it. I asked her, because my understanding was that after April 1st, there couldn't be any other. It had to be a cup, right?
Unless it was an accessory dwelling.
Is that right?
That could be by permit, right?
You're asking how many ADUs have been permitted since April?
Mm-hmm.
I don't know that we have any of those that were permitted after April. I think they were submitted for before. And so before we didn't track the difference, right? It was just STR.
My question was specific to activity post-ordinance effect, April 1st.
Okay.
And so
So
the
no-
testimony of the staff person is that there have been none applied under the CUP process since April. And that's the only way they could apply.
Well, she's asking for the ADU.
Is what?
She's asking about ADU. How many ADUs have been permitted since
Okay.
April 1st?
And you don't have that info, or there haven't been any?
I didn't ask that specifically, so I don't know.
That wasn't on the list of what was specifically asked of Shelby, but we've had that conversation internally, and if any, it's very few. Very few.
And then on R2 permits, the cup that went through the cup process since April 1st, that was 6.
6.
And then 28 that were pending. But that's just cup. So do you have the information on R2 permits by right? How many since the new ordinance?
Well, that'd have to be pending, right?
That would-
Is that what you're asking?
How many have you granted? I mean, how many have applied?
Well, we have voted, I remember at least 3 or 4 things.
That's cut. So we
Right.
don't see all the ones that by right just applied for a permit and are granted by staff.
Okay. 28 applications are pending in R2 for a new permit. Does that answer your question?
Yep.
Okay.
Do you get what I'm asking, Anna? I'm just curious, since April 1st, how many homes in R2 have been permitted as STRs, regardless of the CUP process? I'm just saying, because they can receive a permit not having to go through P&Z council, because the 22 ordinance allows R2 unoccupied. Did we have any information on how many new ones we've got?
No, but we can get that.
And do we know how many accessory dwelling units are currently permitted overall citywide for B&Bs?
Again, I don't think we have done many since the change. It's not been something people have requested, but I know there's some that exist, again, before ordinance change. So there are some out there that may not be technically called an ADU in our system.
I was curious how many. And then what is the penalty for not abiding by this sworn affidavit that's in the requirement of someone living in the home?
You mean what's the penalty for
Not complying by
by
someone
not
signs
having a
this,
local?
yes, I'm living here, but really no one's living there.
So it's a sworn affidavit, so you could be prosecuted for perjury.
Okay.
There's also penalties for essentially tampering or filing a false government record or government document, potentially be prosecuted under that. So are you referring to like a false filing or execution of that affidavit, or are you referring to what would be the penalties if somebody didn't have somebody living there as a local contact person?
No matter. Like what would the city be able to do?
So that would be a zoning violation. So it could be criminal penalties. You can also pursue civil remedies to get an injunction to stop the operation if there's a continuous code violation. That's not STR specific, that's for any code violation. So the same penalties would apply. Just like any other violation of the STR ordinance.
And how does city staff expect to enforce this? I mean, are we going to have people looking in windows at night? Like, how are you going to know beyond sworn affidavit that people are being truthful, that someone is living there full time?
Probably like a lot of them, it'd have to be complaint driven. So if a neighbor has reason to believe and, sees something, so like most things, it'd probably be complaint driven.
Thank you.
You have a recommendation for us to consider with regard to compliance?
I'm just concerned that I don't have information on, again, what we're dealing with, how many or where. And it's hard to make decisions. And I don't.
Does that impact your decision about the language change?
Well, I mean, I understood initially that these definitions would only apply to about 30 homes, but I mean, technically, correct me if I'm wrong, there's no limit to a square footage, right? It's R1, 10,000 square feet. They can build.
The lot must be 10,000 square feet to be eligible for a guest house.
So how many lots are in R1 that are 10,000 or over?
The majority. So yes, those are the ones that are impacted. Those are the ones that could build an ADU or convert something existing to an ADU. And then the ADU can be as large as the main house, as written.
That's concerning to me. That's a lot bigger than 30 homes. 30 lots.
Now, it will, of course, still have to meet parking requirements and impervious cover. We don't really have impervious cover for R1. So all the other rules are going to apply going forward, but technically that would be allowed.
Well, my understanding, and correct me if I'm wrong, obviously, my understanding is the matter before us this morning is to close the gap on what the court has already acted on. And it's not really a matter of how many there are, it's the language that's what we're tidying up. Do I have that probably correct?
We're tidying it up, but it is changing the eligibility.
Oh.
I mean, it is opening it up for more possible STRs.
But there's no way to really tighten it up and be in compliance with the court's opinion, right? Or is there? Yeah.
If you leave it as is, it's vulnerable to being challenged as it's written. So the intent of this change is to narrowly expand the operation of those two types of STRs to so that you essentially protect, I guess, those areas. Because as it's written currently, if you don't make any changes, somebody could challenge that section of the ordinance as written as being unconstitutional, and then that part would essentially go away. You can't enforce it. So by this narrow expansion, you're actually protecting more than if you don't make the change at all. That makes sense. So, really, the change is that these types of STRs, at least the option to operate them, already exists. The location that can be operated is not going to be changed. The only difference is that right now, as it's written, to operate one of these STR types, it has to be the principal residence of the property owner. And with this proposed change, in addition to that requirement, or in lieu of that requirement, you can have a local contact person live there in lieu of the property owner living there as their principal residence. That's the only change. Prior to the ordinance amendment, there was no distinction, at least for the city purposes, of these different types of STRs. If it was an ADU or whole house unoccupied, they were all just permitted as an STR. I think since the ordinance amendment, I know this was just discussed, and we don't have certain numbers, but I recall Shelby saying that there were no applications that have been made to date for this for either of these STR types. So I don't know if this is going to have a huge impact. I mean, there are some ancillary impacts that could, trying to project how it would be used. I mean, I could see potential, some of the things that Jason Lutz mentioned are possible as far as, sort of investor, I guess, maybe investor activity coming back in potentially. But I don't know that you have any option other than, you have to do something, because as it sits, it's likely unconstitutional. So this is trying to be as narrow of an expansion as possible to meet the requirements, to make it constitutional again without, we're trying to limit the amount of ancillary impacts that it's going to create.
Does that answer your question? I mean, we have to do it. We have to get in compliance.
Yeah, I get that for sure. Thank you. I just think this seems like it was an attempt to placate R1, and this is a Band-Aid, and it's just, I don't like halfway fixing something. So I'm really eager to fix it all the way. And I'm realizing that this is what we need to do to get in compliance right now, but I would like to have more information.
I agree, and I think that's what the task force is working on. Correct? Yeah.
Yes. That's what the task force will be working on, certainly in January. We've been dealing with enforcement and the Granicus issue, which has been challenging. Once we get to January, I intend to call a meeting every week and follow through with these other issues. Admittedly, it is a Band-Aid. Am I hearing you say that your impulse is, if we're going to do this, then there may be other things we want to do as well in this decision?
Not here. I mean,
Okay.
I'll stay back. But
overall, you're saying there's still a lot of things to take care of in STR ownership, R1s and R2s. I agree with you about that. I think you do too, what you said.
Speak for me. That'd be fine.
Okay. No, I don't mean to do that.
That's what we think.
Okay. Bobby, any comment?
And I agree with Emily, but that's a lot larger discussion, and I think we'd have to open up the whole ordinance and tear it apart and take a look at it. And I agree that we need to change the wording, getting compliance with the court. The other discussion, I think, is for a later time.
So,
All right. So, yeah, I think we've clarified, at least in my mind. Anybody further? Yeah.
in line with PNC's recommendation along with staff, I move that we approve ordinance 2022-40, amending section 2.100, definitions and appendix of the zoning ordinance.
I'll second.
Motion second to approve. Any further discussion of the motion? All in favor say aye.
Aye.
Any opposed? Motion carries unanimously. Thank you. Thank everybody for your comments and counsel. All right, 7B. This is the one I intended for you to comment on, Anna. I'm sorry. Would you mind going ahead? Consider the following actions related to a CUP requested by Bethany McCullough for a property located at 511 West San Antonio.
Yes, sir. So public hearing notices went out for this item, and Planning and Zoning did consider it at their December 7th meeting. However, the applicant is unable to be here. So staff is asking that we hold the public hearing, but delay taking action until the applicant can be here in January.
Okay.
I move that we go from regular session to public hearing.
Second.
Motion second to go from regular into public hearing. All in favor say aye.
Aye.
Anyone here to speak on this? Come ahead. Yes, please. We want to get you on record and immemorial you. Yeah.
Good morning. My name is Denise Morris. I'm actually here on behalf of Bethany McCullough. She is, or Chelsea, sorry. They're in business together. She has COVID and is unable to make it, which is why she's not here. So she is hoping that we can push it till she can be here in January.
Okay.
That was it.
Well, thank you for being here on her behalf. That's a good friend.
Thank you.
Anyone else? All right.
I move that we go from public hearing to regular session.
Second.
Motion second to go back into regular session. All in favor say aye.
Aye.
All right. We have no further action on this item. No presentation and no consideration until applicant is able to appear, and may she get well soon. All right. Item 8A. Consider the approval of a lease agreement with Fredericksburg Convention District Bureau. Mr. Bailey, would you comment on this?
Mayor, as we discussed yesterday on this particular item, we did receive a number of comments from CBB last minute in terms of the review of our revised lease. We'd like a little bit more time to work with them to get to a point where we can bring that back to council sometime in January.
Means nothing. We're not going to run them out of their building by New Year's.
When I say last minute, we got it in their hands a little bit late. They may not have had as much time to take a look at it and make comment, but we want to give it a little bit more time.
Yeah, for the public, I want to comment. Excuse me. That I read their request for expansion, and they're all very substantive, and I appreciate that. But it doesn't mean anything to their lease or anything. We do it month to month anyway, right? Right. Okay. All right. So, council, this will be tabled until further. Do I need a motion on that, or can I decide? Okay. 8B, consider awarding a construction contract for the East Main Street Waterline Rehabilitation Project to QRO MEX Construction Company for 1.7 million. Mr. Knazy.
Good morning, Mayor, Council. Excited about this project. This is a project we've been working on for quite some time. Starting back in the planning phases, back in 2017, when we completed the Water Master Plan by Friesen Nichols, this project was identified to replace aging infrastructure that had been in our system for a long time. On page 48 of your council packet, there's a map showing the extent of the project. It goes from French Creek Bridge by McDonald's all the way down to Crystal Drive, close to the UPS store. Again, this is a waterline project that ranges in size from 6 to 8 inch water mains, has a lot of aging infrastructure, a lot of main breaks. If you've driven that westbound lane on the outside, you see a lot of areas where we fixed those water lines and those main breaks. Some of those are due to base failures and so forth by TxDOT, but a lot of those are issues with our water line. So again, this water line is located within TxDOT right-of-way underneath pavement. A lot of it, we are working with them and have designed the project to remove some of that out from the pavement to be behind the curb. But TxDOT, generally speaking, is on board with replacing this so that we don't have to keep tearing up their pavement. They do have a mill and overlay project that is looking to be completed hopefully later this year or for sure next year. So we're trying to get this water line replaced prior to that construction project, doing that full mill and overlay. Back in February, we hired HDR Engineering to complete the professional design of this project. bid phase services. We took the project to bid, publicly advertised for 3 weeks, starting back in October. We received 7 bids on November 17th at the bid opening. I'm proud to say that the bid atmosphere has gotten better. I was expecting maybe 2 or 3 bids. We received 7, so that's great for the replacement of this public infrastructure. The bids ranged everywhere from about 1.8 million all the way up to 3.6 million. Engineer's estimate was about 3.3 million. And so low bid was 1.7, almost 1.8 million dollars. Our budget is $3 million for this project, so we'll realize about a $1.2 million savings. Again, seeing that bidding atmosphere really change to our benefit. Chromex Construction Company is the contractor that just finished our major waterline project out 290 East, so we're very familiar with them. Have a lot of really positive experiences with them over the duration of that project, so we're excited about working with them again. Be happy to answer any questions that you might have. I am recommending approval of this construction contract, which will begin after the first of the year. Be happy to answer any questions you might have.
Mr. Bailey, can you speak to the issue of the excess from bid to the budgeted amount?
Sure.
How that will, what's the plan?
Sure. And we first of all, we develop an engineering estimate for these types of projects, and this particular project luckily has resulted in a much lower bid than the estimate. So what we will do during our mid-year budget amendment is we'll have pluses and minuses in that amendment. This will be a plus. We have identified a few items in the water department that are additional budget needs. We will also have those in front of the council for consideration that will likely reduce this positive amount being added back to the budget. But all of this will be wrapped into that mid-year budget, and you'll see the savings again and again, a few extra projects in there that borrow from that savings.
I'd like to request that we, if it's okay, I mean, if I'm not missing something big, that we hold off any further on that until we see how the economy is going to roll out in the early part of the year. I think that's got a lot of us anxious.
Absolutely. We'll probably be looking at this in May or June. Yes, sir.
Thank you, Chris.
Absolutely.
Questions, council?
I have a question, Chris. I'm sorry, I'm not seeing it, but in the pages 52 to 54,
Yes, ma'am.
where is the bid for QRO Met? Is that these are
yeah.
all higher?
So on page 52, it's actually the first bid. So the first.
Okay, I'm sorry. I
column.
wasn't reading it correctly. I was just looking bottom right.
Yeah, so the rows are the bid line items, and then the actual bids you received are the columns.
Perfect. Thank you. And what is this going to look like? Is it all going to be under 290 on East Main, or are parts of the road just going to be blown up for a time as we go down, or how does that work?
We're working with the contractor, but it'll be sectioned off for the particular area that they're replacing. They'll finish with that section, then they'll move down. There'll have to be some tie-ins later on in the project, so essentially all the water services have to remain in place and serving those businesses and homes. We'll install the new water line and then come back, do the tie-ins, do the flushing or the testing requirements by the TCQ before putting that into service and basically changing all those services over that new line. So it'll be interesting. The traffic control is obviously a big component of that, working with those businesses, making sure driveways remain open. Talking with the contractor now about scheduling and making sure everything is open on Fridays and for the weekend, those sort of things. So there will be a lot of coordination through the project with TxDOT, City, and the contractor.
Thanks. And this is timing wise. This is coming before TxDOT is doing any improvements on 290, right? So
yes, ma'am.
Great. Thanks.
Chris mentioned it, but it is going to be very critical that we communicate and coordinate with all of the business owners up and down Main Street. That's typically the most critical part of a project like this in the location that we're doing the work. So we'll work really hard on that with the contractor. As Chris mentioned, to get out of the way for the weekend to make sure that everything's open so that they can be as business as usual as possible.
So this is not a pipe bursting.
No, sir. Open trench.
Okay.
Yes, sir.
I have a question. I apologize if it's a stupid one. On page 53, $48,400 is highlighted for iron
Yes.
fittings for a buried water line. Is there a reason why that's highlighted?
Yes, ma'am. That particular contractor, we had an addendum to the bid documents that changed the quantity of those fittings, and that bid did not reflect the change from the addendum. So the engineer, HDR, just highlighted that, so their actual their bid amount changed because they didn't change the quantities in their addendum or from the addendum. So again, that's with a different contractor we're not considering, but that is the reason because the addendum changed the bid quantity, but this particular bidder didn't reflect that change in their bid.
Got it. Thank you.
Yes, ma'am.
So it really should have been 110,000. That's what it is on the bid you're proposing, right?
The bid I'm proposing is on page 52. It's the first column.
Yeah.
From X Construction.
On that same line 17, iron fittings for buried water line, 110. It was 48 on the other one. So the 110 is correct. And 48 was in here on the other bid, right?
That was a different contractor.
Yeah.
Conseco Construction is the 110. The contractor that we're considering this morning is actually a bid for $68,750. So it'd be the first column here.
Got
you
it.
have the unit price and the
I got it.
price.
Thank you.
Sorry, it's a little confusing.
I'm
with
sorry,
the
I was
small.
on the wrong. I thought the whole page. I got it now. Sorry.
No problem.
You mean you don't look at these kinds of things every week in your business?
Maybe it's the print's too small for my old eyes.
It certainly is small. It is small. My
Thank
apologies.
you. Thanks for your patience.
Anything else, Councilor?
I move that we approve the East Main Street Waterline Rehabilitation Project with Hero Mex Construction Company for $1,790,655.
Second.
Motion second for the approval. Any further discussion? All in favor of the motion, say aye.
Aye.
Any opposed? Motion carries unanimously.
Thank you.
Thank you, Chris.
Thank you, Chris. 8C is consider, discuss, and take action on the Ladybird Johnson Golf Course Facility Management Agreement with Touchstone Golf LLC. Mr. Bailey?
Mayor, Council, we do have Chris Mead, Regional Manager of Touchstone Golf, with us today. Chris, you might want to get up to the podium just in case there's a question. This is the lease renewal for the lease of the golf course. We're at the end, nearing the end of the first 5-year contract with Touchstone at the end of this month. As Chris presented last time, they've done a wonderful job. They're in a very good position. The state of the golf course, condition of the golf course is in great shape, and they're doing very well financially, setting records month over month. Chris is shooting for a record revenue number year end. I think he mentioned that $2 million number. That's about $500,000 over projected revenues. So again, some of the capital projects that we've done in the past, some of the projects we'll be contemplating in the future are made possible by that excellent performance of the golf course. Regarding the contract renewal, again, we initially engaged Touchstone in a 5-year lease agreement. This is a 10-year term. That's one of the major changes. A 10-year term with 4 automatic extensions for 2. Let me back up. 2 automatic 4-year extensions at the end of that 10-year period. We also have a slight increase in the base management fee from $5,000 to $7,000 a month. Those are the major changes. I might ask Chris to talk just a little bit about their reasoning for a longer term where they've done this in other locations, again, based on a similar performance at Lady Bird. Chris, if you don't mind.
Thank you. Appreciate the time. So we have the two proposals that you have. The one we're most interested in is the 10-year term. This is the same agreement that we entered into with the City of Austin. We operate Great Rock Golf Club for the City of Austin. So this mirrors that agreement that we signed a year ago there. What it does is it really makes it easier for us to line up successory staff, or not that I'm attempting to go anywhere, but it's easier for us to plan our resources as a company, knowing that we're going to be in a facility for X period of time. So the monthly does go up, but the incentive fee is a lower percentage than we've seen in the past. So it comes down to a 15% EBITDA improvement versus what we have been operating under, which was 30. So it makes it easier for the city to, in our opinion, to budget their expense versus for the operations, as not get a huge incentive bill at the end of the year. And it allows us to, once again, line up additional staff or make sure that we have long-term staff in place should someone move on in the facility.
We did not include it in the packet, but we also have a version of the new lease with a 5-year term versus 10-year. Again, staff recommends moving forward with 10-year, as Chris mentioned, as he's hiring first assistant pros and trying to get other folks on board that might want to live in Fredericksburg. That gives them a lot more security. We can attract higher caliber people, again, keep them here longer in the Touchstone organization.
What's the provision in the contract for something that would never happen, which is non-performance or breach or something like that? Because 10 years is a long time.
Right. I might turn to Daniel to talk just a little bit about
standard stuff.
Right, it's typical. So the agreement can be terminated by mutual agreement of the parties. It can be terminated if there is a material breach that's not cured within 15 days after written notice. If it's the type of default that can't be cured within 15 days, at least need to commence their curing attempt in that time period and continue it until it's cured. If there's gross negligence in the operation of the golf course by Touchstone, you can terminate immediately. And then Touchstone can terminate immediately if the city fails to pay them the management fee. So in the case of failure to perform, there are remedies for the city to terminate the contract. And I did review this contract. It's very similar. Most of the provisions are identical to the contract that was entered into 5 years ago. As mentioned, there's a little bit of restructuring with the compensation. It's actually simpler now. There's an additional lease fee in there before that's not in there now. And I had a few sort of minor changes that have been incorporated into the version that's before council today.
So, Chris, you'd say that there's a substantive difference in your ability to perform on your business model between 5 and 10 years?
Recruitment wise, yes, sir. That's the main difference. Is we can hire frontline people, but when you're trying to hire that middle management that grows to a general manager and beyond, you get children involved in home purchases, and the fact that they know that they're there for X period of time makes it easier to recruit that level of employee.
It's your company's view of getting the best people and keeping them a longer time.
Yes, sir.
Other questions, Council?
One finance question. Remind me, where does the management fee come out of? Is it general revenue or is it?
Is golf still an enterprise?
Is it under parks?
No, it's not.
Golf is its own enterprise, isn't it? Used to be.
Right. Golf course is its own fund, right? I would have to check and make sure. I don't want to misspeak.
Is it?
I want to say it's a general fund. Chris might know the answer to that, having looked through the budget recently. Good question. I really don't know off the top of my head. It could be general fund.
I think it is general fund.
I think management is general fund, and then all other costs are covered by.
That's
covering
correct.
it.
Yes, ma'am.
Thank you.
How quickly we forget after we spend 4 months in a budget. All right, so if you will forward that information to Councilman Hurst. Anything else?
I'll make a motion to approve as presented.
Second.
I have a motion second to approve this contract as presented. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you, Chris.
Thank you very much. We look forward to the continued. And
I guess we'll see you in 10 years. Maybe before. Item 8D, consider the approval of a performance agreement and associated financial security for 110% of the cost of the remaining public improvements required for completion of the Allstott Village Phase 1 subdivision. Evan, oh, hi there. Good morning.
Morning, Mayor and Council. Quick little item to bring before you this morning. Our subdivision ordinance provides an option for developments to enter into an agreement with the city to defer some of the public improvements required to record their final plat. The Allstott Phase 1 subdivision, you can see in your packet there, it is at the east end of Center Street. It's approximately 23 lots. The public improvements are currently under construction. This agreement would provide financial surety for the completion of the first and second courses of payment. And this is accomplishing two things. First, for the developer, that would allow them to record their final plat before the end of the year. This would give them the ability to fulfill an agreement that they had with the seller of the land to convey lot 1 back to them that has an existing home on it before the end of the year. So that's one function. The second is they would actually defer the second course of payment to the end of the 2-year warranty period. And this would allow home construction to take place with that first course of payment in place only. And then they would come in at the end of their warranty maintenance period and be able to refresh the pavement, clean up the streets, address any defects that has been a problem in the past. This would be similar to the Post Oak Road subdivision that is under construction. They are also in their 2-year warranty phase and are deferring that second course of payment through a performance agreement. So they are providing financial surety, as you mentioned, in the amount of upwards of $94,000, equal to 110% of the estimated cost of those public improvements that they are deferring. And we've reviewed the quantities and the costs for those, and approved those. So today we're coming before you and recommending approval of this agreement.
Any questions of Evan?
I'll also mention that the developer's
Mark, did you want to comment?
So if you have any questions for them, he's also available to answer.
Anything you want to add, or you're just here for questions? Okay. I don't mean just here. I mean, are you?
I'm sorry, I might have missed this. When is the development going to be completed? Home's ready for move-in?
Development is very close to completion. Home construction could start January, February timeframe, if they're ready for that, but they haven't really got their plans to submit building permits. The main purpose of this is they have a lot 1 that was supposed to be conveyed to the seller, and but we're right at the point of paving. The crew's out there working on base now, but as you know, the weather is about to turn bad, and that's not conducive to paving. So the paving ends up on a subdivision in the wintertime, really slowing the final completion. There's a lot of administrative tasks that have to occur on a plat, and it takes a lot of time for all of that to occur before you can even submit for building.
Thank you.
Total build out of phase 1 is how many?
I have 24 in my mind.
Okay.
I'm sorry, I don't know if that's
I
right.
couldn't remember if it was 24 or 34. Okay. 24. Yeah, 20. Is that what you remember? 24
Lots.
Yeah.
The plat is also attached. I believe it's 23 lots.
Yeah. All right. Further comments or questions?
I move that we approve the performance agreement with the Allstott Village Phase 1 subdivision.
Second.
I have a motion in 2 seconds to approve this performance agreement. Any further discussion? All in favor of the motion, say aye.
Aye.
Any opposed? Motion carries. Thank you, Evan. Thank you, Mark. Merry Christmas. Okay, where am I? All right. There we go. Item 9, City Manager's Report.
Okay, Mayor Council, we'll start with the standing item, short-term rental permitting and code enforcement, and I'll ask Garrett and Hannah to help me with this particular item. So a lot of work on the permitting side, a number of different meetings with task force members and Granicus as recent as yesterday. And again, as we're taking a look at Granicus working through some issues, our hope is that we can continue utilizing Granicus to maintain our permitting. We put a lot of work into this so far, but at the same time, we're developing more of an in-house option. We just discussed yesterday in a meeting at City Hall with members of the STR task force, including Mike Hogan, who mentioned he's working on a module that he feels he can have put together within about a month that will allow permitting renewals, and so forth. Some of the things that we've been working with Granicus for some time to try to accomplish. We did have a conference call, a Zoom call with members of Granicus last week, senior level members of Granicus last week, and I'm not sure at this point we're going to be able to get to a good point with them. The software that they offer, it's software as a service, and really the management of data that we're doing now does not fit their model. The input of data, what we're getting out of the system, Granicus system, does not fit their model. Software is a system or service, is my understanding. There's very little customization available with that type of application. There are some other issues that we've been working through with them. The beta version of the software that we were given initially, there's nowhere in the agreement where we asked for, we're told we were going to get a beta version. So I think this has been in development as we've been moving through the last 7 months or so. But the bottom line is our processes don't fit their software all that well. It's not customizable. So we're moving forward with a parallel path. Again, trying to develop something that will meet our needs, developing that in-house. I will mention that we did put together a list of 6 questions. Do you have short-term rentals in your city? Are you managing those with a software system? What is that software system? Do you have staff doing that? And sent that out. Shelley sent that out to 7,000 municipal clerks across the state of Texas and a little bit outside. We're starting to get some of those responses back, and the responses really vary depending on the size of the city, how many of these units are in a city. I'll give you an example. The city of Blanco has 20, so they rely on one staff person to do all of the permitting, all of the renewals, all the hot collection, and so forth. I think Addison has 385. They use an existing permitting system that they utilize for code enforcement, development services, a few other things. Again, not that many in combination with staff. When you get into cities like Port Aransas, we had a visit from 2 Port Aransas council members yesterday. Mayor, a couple of the council members that we visited with down in San Antonio months ago, Joe Kruger and Tim Park. We had about an hour-long conversation. They're using GoOS. They have about 4,000 STRs. 85% of their entire housing stock in Port A are short-term rentals. If you talk to people that own STRs down there, Jim Giroux is a good example. He thinks that the permitting system is working fairly well. However, they're having some of the same issues that we're having mainly with scraping the internet and identifying those that might be operating without a permit or different occupancy, those types of things. So they're asking questions about Granicus, if that's working for us and so forth. So again, when we look at these responses, it just varies depending on the size of the city. It looks like, again, there's either a staff person managing this, they have built some kind of system in-house in combination maybe with an existing permitting software they were using for something else. But at the same time, a lot of them are trying to use the Granicus GovOS type systems with limited success. Wanted to also mention from our meeting last week with Granicus, we did ask for a list of cities that are using Granicus with success. They have provided us with a list of a couple of cities that we're beginning to visit with. Again, if we don't fit their mold, I think it's going to be very difficult to end up in a good place with them.
I have a question.
Yes, sir.
My understanding of the conference call was the report that I got was that there was more conclusiveness about it than what I feel like you represented.
Okay.
That there was more conclusiveness about the knowledge that Granicus was not going to be able to serve our needs. Did I get that wrong?
We should have an answer to that question end of this week. Was what we asked them for and what we're waiting on now. Correct. And again, it just seemed to me like, is that what y'all heard, Garrett, Hannah?
So I think we finally have a clear understanding of the limitations of their system and what they're willing to customize for the city, which is basically nothing. So at a staff level, we're looking at how we could adjust our processes to fit their system. We've asked them to do the same to see what they would recommend we change, because I think they do have a clear understanding of what we're looking for. But we do have a follow-up call scheduled for this Thursday. So as Clint mentioned, I think we'll have a lot better feel of whether we want to continue this discussion with them or just call it quits after that meeting.
What if they come and say, yeah, we've not done a good job, but if you buy these extra things, we think we can fix your problem?
Well, I mean, we asked that question, because they did indicate they're not willing to customize the system. We said, okay, is there an additional service y'all could propose to address the situation we're in? And at that time, they didn't sound willing to do that.
My impression of talking to staff who deal with this on a day-to-day basis and the discussions we've had in the task force is that the best predictor of future behavior is past behavior. So if they come and say, we think we can do all of this or with extra time or extra components or whatever, my recommendation is no. Is that accepted?
Right.
I think we feel similarly.
Right. We as staff, we all feel the same way, Mayor.
Okay.
We don't feel like they're going to be able to meet our needs in the end.
Well, I appreciate y'all working with this. I know it's been harder on y'all than it has on me, but I've made my decision. So.
And we understand that, and we are moving forward with that parallel path, and I feel really good about that. We have had our IT department involved in the entire process. So I'm feeling good moving forward. We have a number of individuals, various backgrounds that are looking at this, and it's really been helpful. Thank you.
Can you remind me how many city employees are working solely on STR issues, and then how many don't deal with it? Might not be entitled, but how many?
Sure, and I'll start. We have 7 individuals in development services. We've added 4 to specifically deal with STR issues. 4th would be Mr. Joe Mursky, who is our administrative hearing officer, a code enforcement officer, STR specialist, who you met last time, and then also a hot collections specialist. In addition to those 4, we have myself, Garrett, Anna, Shelby, and our 2 code enforcement officers, I would say.
Janelle should be our purchasing agent, but she's primarily dealing with hot remittance for STRs?
About 10 people, or 10 to a dozen people work. And again, it does take up a lot of staff time, but we understand this is a very important issue. We want to get it right moving forward, get a system in place. Just managing all of the information takes up a lot of time.
Thank y'all. Thank you, all 11 of you, for your.
Agree.
And I did want to report we have extended offers relating to the third code enforcement officer. That gentleman has accepted our offer, so he starts work I think January 9th. And additionally, the hot collection specialist will be starting on January 5th.
An update on the code enforcement side, and Anna, you can add to this. Since November 15th, we've had five major violations. We consider major STR violations. One of those was a noise issue at about 1:30 in the morning. As I reported to the council previously, we also had a non-response from the local contact person. Plan is to route those through municipal court. Dr. Shelley Becker, this morning I attended municipal court on the 13th, and there was a STR permitting issue. She couldn't give me any detail on what the permitting issue was. That will be considered after the first of the year. We did have two more nuisance complaints, noise complaints that came through PD a couple of weeks ago. Neither one of those resulted in a violation. On the code enforcement side, we've had about 110 different code violations. About 50% of those related to short-term rentals. The majority of those are trash violations. There were 4 that we routed through the administrative adjudication process. We had a hearing scheduled for December 6th. No one showed. They all paid online. Those were watering violations, I think trash violations, and so forth. I don't know if you want to give a further update on that, but things have been pretty quiet in the neighborhoods in terms of STR major violations the last couple of weeks. Do you want to add anything to that, Anna?
I think you covered it all.
I'd be happy to answer any more questions the council might have.
You fully answered mine. Thank you.
Okay, moving on to recent staff promotions. I have 3 promotions to announce to the council today. Starting with Garrett Bond. Last week we officially promoted Garrett Bond to Assistant City Manager. He has been on board since 2015. Garrett's the kind of guy that always steps to the plate, always does the right thing, fills in. Most recently, the interim director of development services, where he did an excellent job. Tremendous role model for the city organization, just his work ethic itself, his local knowledge, ability to work with very difficult people. He and Chris have truly both been my right-hand men for some time now. So Garrett has definitely earned this promotion. I look forward to having him even closer to me, involved in a lot of the higher level issues that we continue to deal with in the organization. We're not prepared to discuss exactly the departments that Garrett will provide oversight to at this point, but we'll provide that information to the council as we're working through his 6-month goals and so forth. But excited to have Garrett in that position. He's done a wonderful job. He's earned the respect of, I think, P&Z, the council, members of the community, the city organization. He's definitely a leader in the organization, a leader in the community. Garrett, I don't know if you want to say a word. I don't mean to put you on the spot.
No, I just want to thank Clinton for his guidance and leadership, and I look forward to continuing to work with the mayor and council. A lot of exciting things coming up.
Congratulations.
Thank you.
Okay, the next promotion, Chris Canese. Recently promoted Chris to the official role of Director of Public Works and Utilities, City Engineer. Chris has been in that interim role again since May. Chris came on board 2012 13 just before I came on board. Again, Chris has really grown in the organization. All of these promotions are a really good example of our employee succession program. I've really thrown out some difficult situations to both of these guys, whether it's projects, working with council on issues, working on staff issues. They've both risen to the top. But Chris is a licensed professional engineer, as is Garrett. Chris also holds a master's degree in engineering. His area of expertise is water, wastewater. You've heard him talk quite a bit throughout the budget process as we continue down the road. Especially this year, we have some projects in that vein that we'll be bringing in front of the council. So again, Chris's leadership, he has certainly grown over the years. I have all the confidence in the world in Chris. He's developed a really good relationship with the entire Public Works Department, all of the department directors on staff, city employees. Chris was also very critical in getting maintaining the water supply throughout the ice apocalypse event that we had. I can remember I don't even know how many issues that we were juggling that day. And I told Chris, I said, this is the issue, fix it. And that's all I told him. And he worked day and night to get that done. So I have that kind of confidence in Chris. He always keeps me informed. Again, a true leader in the organization, has certainly earned the position. And so congratulations, Chris. I don't know if you want to mention anything.
Thank you, Chris. Congratulations. We lose our audio.
Mine works.
There you go.
Is that working? Okay, that's working again. As our staff engineer, he's been in that position for a number of years now. Evan, was it a couple of years ago, became a licensed professional engineer. He came on board as an engineer in training. Again, we've thrown out some very difficult projects to Evan. He has certainly measured up, risen to the occasion, from the development update that we gave with development services to items like we had tonight. It's also this morning, he's also a big part of the development process, an up-and-comer in the organization. Definitely has recently been promoted to assistant city engineer. So the same title that Garrett has held for a number of years will be a direct assistant to Chris Canese. Congratulations, Evan.
All the best.
That's all I have this morning, ma'am.
Thank you, Clint. Number 10, items for future agenda.
And right now, the only item we have on the first meeting in January is the meeting minutes.
Do you think that the CVB lease might be ready by then?
The CVB lease will be ready by then. I think we have a couple of other items, Shelley.
What's that? Oh, okay. Yeah, the applicant postponed. Okay. That's Mueller? Do we say Mueller here?
We just said Mueller, but that one's coming later.
Okay. Mueller?
I've heard it called both.
Okay. Go ahead.
So fairly light agenda for the first meeting in January.
We'll ease out of the holidays.
Mine's dead.
There you go.
I have one. Can you hear me?
Yes.
Test. I have a comment on the ordinance that was adopted today, 2022-40, the STR text amendment. If you can look at page 24 of your agenda packet. Let me know when you get there and I'll walk you through it. So, an error in the draft that's before council that I would like to bring to council's attention. The first paragraph on page 24, the first whereas, the recital paragraph, it makes reference to a motion by council to clarify the measurement of a building height. That's obviously incorrect. That's from a previous action that was taken a year or so ago. So that paragraph should read that the action that to amend the residency requirement was initiated by council. That's the intent of that paragraph. So I would like to revise that before it's signed by the mayor. And so let's bring that to the council's attention. You can make a motion if you want to amend the adoption to correct that paragraph. If you want to do so, I don't know that it's required. I mean, this is not really a substantive change. I just want to make the council aware of that the adopted ordinance will not have that paragraph. Instead, that paragraph will reference the motion that was made, I believe, by Ms. Kirchner to amend the residency requirement for STRs.
Okay.
Additionally, on the next page, agenda page 25, if you look at the heading that says short-term rental B&B, it should say short-term rental, comma, B&B, and not a period. So that's another change. It's pretty small, but that's another change that will be made also.
Okay.
And then finally, the Exhibit A, which is the proposed form for the local contact person, the principal, the affidavit of residency. This is not the final draft. There were no changes to the text. There was just a little bit of reorganization to the formatting of it. So essentially, you just got the prior final version in your packet. So so three changes are that first paragraph in the ordinance will be amended to reflect the motion that was made by council. Second change will be to change the paragraph, or I'm sorry, to change the period to a comma after short-term rental in the short-term rental B&B. And then the third change will be on the exhibit. It will look almost identical. There's just a little bit of movement of some of the text on this to make it look a little more presentable visually.
Well, to validate the action today, do we need another motion with those provisions?
I mean, for the cleanest record, that would be the recommendation. I don't know that it's required, but if council is willing to do so, you can go back to that item and adopt it with the
I'd like to do that, council. Somebody make a motion to approve the recommendations of our city attorney regarding this, the written part.
Didn't you make the written one?
It doesn't. I mean, technically, you need a motion to revisit the item first, and then since it's already been acted on, and then you can reopen it, and then anybody can make
a motion to revisit this issue.
I move we revisit the short-term rental amendment in light of city attorney's recommendations.
Second.
All right. Motion second to revisit the issue in this meeting on this item has been disposed. All in favor, say aye.
Aye.
All right. Now we can accept a motion on specifics with regard to the city attorneys. And will staff come up with a language? Is that on this first paragraph?
Right. I will redraft that first paragraph, and it will just reflect, instead of saying related to the measurement of building height, it will say related to the to amend the residency requirement for operation of short-term rental accessory and short-term rental B&B.
So yeah, we didn't do anything about building heights. So that will need to be amended. Thank you, Daniel, for doing your job so well and being a senior.
Trying to go out on a high note.
That's okay. And so we're tidying up the document. Guess we need to read the whereases more closely. Okay. All right. Everybody understand what we're doing? Okay. Motion.
My last official ability to request something of the city attorney regarding the ordinance Z2231 7A. I move to direct the attorney to edit the first paragraph to change the motion to whereas to amend the residency requirement, not building height. and then changing a period to a comma on the definition of B&D, and then some minor reformatting to Exhibit A.
Is that the right ordinance number?
I think you referenced the application number. The ordinance number is 2022-40.
I just want to make sure we'll make sure to get the number right, but we know what we're talking about.
I'll second.
All right, motion second. Is that an adequate motion? All right. Any further discussion? All in favor of the motion, say aye.
Aye.
Any opposed? Thank you, sir. Thanks, council. All right, we're almost at the end of the agenda today, except for executive session. But it is only 10:37. Wouldn't y'all like to hang around till 2:30?
I don't have anything.
Take a break
Yes.
and come back. Okay. All right. We do have executive session this morning. 2 items to consider and discuss the appointment of a public officer employee, specifically city attorney, and consider and discuss purchase, exchange, lease, or value of real property, specifically public utility easements located in the vicinity of the intersection of Highway 16 and Highway Street.
I move that we go from a regular session to executive session.
Second.
Motion second to go from regular into executive. All in favor say aye.
Aye.
Any opposed? All right. Thank you, folks.